This is a lecture about professional responsibility, and we're going to be talking about Model Rule 1.2. ABA Model Rule 1.2. By the way, we finished our, if we're going through the course in order, conflicts of interest. We're still in the kind of general cluster of rules about the client-lawyer relationship. And so from the ABA standpoint, they put all the rules that are about, that pertain to the client-lawyer relationship, like fees and things like that, start with 1. Let's say the rules about litigation, like duty of candor to the court, start with 3. Advertising rules start with 7. But all the rules that start with 1 relate to the relationship between the lawyer and the client in some way. Then 1.2 is about the scope of the representation and the allocation of authority between the client and the lawyer. That sounds like a mouthful, doesn't it? Well, the scope of the representation, what we mean in a nutshell is, what did you actually agree to do or agree that you wouldn't do for the client? Sometimes clients come in and they hire a lawyer for a legal matter, and then they think that that lawyer is their lawyer for all their problems. And so let's say their insurance company, they get in an accident, their insurance company gets them a lawyer for their accident case, and now they want that lawyer's legal advice about, like, they want that lawyer to bail their kid out of jail and handle their divorce and sue their employer and draft their will. And the lawyer's like, I do insurance defense work, I don't do wills, right? And so it's pretty common that a lay person, a non-lawyer client, thinks that you're like their lawyer for everything. And so you have to spell out and limit the scope of the representation. And then allocation of authority is who decides what in the representation. So here's A, which starts out saying, apart from the exceptions in C and D, a lawyer shall abide by a client's decisions concerning the objectives of the representation and, as required by Rule 1.4, that's our communication rule, consult with the client as to the means by which they are to be pursued. So please note, I put objectives and then means. Objectives is in bold, and allow me to explain for just a moment. The client comes to you, they are in the driver's seat about what we're trying to achieve in the litigation. This rule, by the way, does not seem to be on the radar at all of Hollywood scriptwriters. Every lawyer show I watch or lawyer movie, it seems like part of the plot is that the lawyer's representing a client, and then the lawyer decides that they know better than the client what the client should be trying to achieve. Like, no, I'm not going to let you sell your family business. Or, no, that's a really bad idea what you're trying to do. And so they decide to the lawyer decides that they're going to like fight for justice instead of what the client wanted or something, the lawyer's conception of the right thing. And that works great as a plot twist in Suits, or Ally McBeal, or Boston Legal. I've seen it in all of those, or The Practice. But in real life, the client gets to decide, right? And so if the client's like, I actually don't want to sue, or I don't want to embarrass this person, or I don't want to do this, then that's their call, and ultimately the objectives of the representation. Now, when it comes to the means, like what do we file? Should we hire experts and things like that? We expect that you're going to consult with the client and communicate with them, especially if it's something the client's going to have to pay for. But generally, the client you don't have to ask their permission to write a reply brief to the other party's motion for summary judgment, right? Now, the client decides whether we're going to litigate or just ask for compensation or something like that, but they're not going to make every little decision in the representation. Okay, let's go back to our rules for a moment. This is the rest of 1.2a. A lawyer may take such actions on behalf of the client as is impliedly authorized to carry out the representation. This is important, right? So you don't have to ask the client to proofread every brief, or if it's okay to cite certain cases or things like that. Generally, if the client says, look, I need you to file a lawsuit for me, or look, I'm being sued and I need you to defend me in the case, you're going to draft pleadings and file them, right? You're going to get the information you need. You're going to double check whatever you need to double check to make sure you're saying the right stuff, and then you're going to file the pleadings. This might be different if you are representing a corporation and in-house counsel, another lawyer has hired you. they may want to review all of your work. But normally a non-lawyer client who hires you, you don't have to go back and ask them about every little thing. If you do, it starts to look like that Seinfeld episode where Jerry Seinfeld wants new cabinets put in his kitchen, and the carpenter is asking him about every little hinge and screw and nut and bolt and stuff like that, and it starts to drive Jerry crazy, right? So you don't have to ask your client about every little thing you do. But if they tell you to do something, that impliedly authorizes you to do all the things necessary to further that goal, or to undertake that endeavor. Notice that that's next sentence. You shall, I should have put that in all caps almost, abide by client's decision whether to settle a matter. Almost guarantee you will get a question on the MPRE where the client wants to settle a case and the lawyer knows it's a terrible idea, it's a lowball settlement offer, or it's a it's a really terrible settlement offer, and they were going to win at trial and win big, let's say. And well, the client wants to settle. The client gets to decide that. You can try to talk sense into them, but ultimately that decision has to be the client's. You don't get to decide whether to settle or not without talking to the client, or to go against the client. The client says, I don't want you to settle, and then you say, fine, we'll settle. In a criminal case, the lawyer shall abide by the client's decision after consultation with the lawyer as to a plea to be entered and whether to waive a jury trial and whether the client will testify. And I hope this reminds you of the McCoy case I talk about in a separate video lecture from the Supreme Court, too, which would have fit under this part of 1.2a. So we have three things here. First, the client gets to decide whether or not to accept a plea bargain. Ultimately, it is the client's decision. Now, you can inform the client, you can encourage them, you can plead with them, but ultimately you are stuck with their decision even when you know the client isn't doing the right thing. We have a couple other things: waiving a jury trial and having a bench trial, and whether the client will testify at trial. Obviously, most lawyers would prefer that their own client not testify at trial. There's so many things that can go wrong, right? The client's going to be cross-examined by another lawyer, and it could blow up the case. Sometimes the client, there's a risk of perjury. There's the risk that they'll contradict themselves or something like that. A lot of lawyers don't like that loss of control and would prefer not to have the client testify at their own trial. But ultimately, if the client is insisting on it, you have to let them. That's their call, according to the ethical rules. 1.2b, a lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economic, social, or moral views or activities. And so this is for all those people who say, how can lawyers represent those people who you know are guilty? And sometimes when we're doing a live class, I'll have a little discussion about this. And so let's take one of these heinous crimes, a mass shooting in a school, or one of these rampage shootings that are just sickening and that seem to happen more and more frequently as time goes by. And so now normally the people that do these kind of rampage or active shooter incidents, these rampage massacres, die at the scene, either by their own hand or in a hail of gunfire. So most of them go into it assuming they're not going to come out alive, I think. On the other hand, we've had a few, like the shooter at the Parkland shooting and the Aurora, Colorado theater shooting, and the Santa Fe school shooting, where they have survived. And they go on trial, and at the time they're apprehended, they are public enemy number one. And the question is, could you represent them? And now, if we have when we have a live class, I'll get pretty animated, like crossfire going in the class, about whether people would represent them. And you don't have to. Please understand, if you have a strong ethical violation, a problem with it, it really bothers you, the idea of representing a mass shooter, or the Klan, a white supremacist, or someone like that, someone who stands for something that you find abhorrent, you don't have to be the lawyer. That's okay. On the other hand, if you can set your feelings aside, then it is okay, and you cannot be subject to discipline it's not unethical to represent someone who's unpopular. And we should not assume that just because you're representing someone that you agree with everything they think or say, or that you think that what they did was acceptable or okay, right? We don't think that representation means personal agreement. This is a point, if you have talked to non-lawyer friends and family at family reunions since you've been in law school, it's a very common point that non-lawyers bring up as a critique of lawyers. Like, how could lawyers represent someone that we all know is guilty? And so I want to tell you a quick personal story. Back when I was a new professor, I became a professor in 2003, and in my first year or two of teaching, the United States was doing the invasion of Iraq, and eventually we captured Saddam Hussein. And I had one of my first opportunities as a professor to be interviewed on the evening news about the legal ramifications of this. I was teaching criminal law at the time. And during the interview, they asked me, would you represent Saddam Hussein? And I said, of course I would. Of course I would represent Saddam Hussein, even though I totally think he was a mass murderer and a horrible dictator and so forth. I'm glad he's gone. Not a good guy. But why would I? Well, besides the fact that I would be famous, right, as the lawyer who represented Saddam Hussein, the other thing is, you know, part of what makes us gives our legal system legitimacy and moral authority is the fact that we give someone, even the person we kind of all know is guilty, even the worst criminals, we give them a chance to tell their side of the story or explain some mitigating factors or just plead for mercy, whatever it is. And we give them every chance in the world, even if we do end up condemning them, right? And and I want this not for Saddam Hussein. I need this for us. I would represent him for the rest of us, because the day we decide this guy is so bad he doesn't deserve a lawyer, then we've headed down the road where anybody who's part of an unpopular church or religious group, or is the part of the wrong political faction or something like that, can end up being rounded up and condemned without a trial. I would want a trial, and if I was accused of a crime, even if I did it, and I think we deserve that. We deserve as a people to be a people to have a legal system where someone will represent that person at trial and try to put on the best case possible. And even if the just outcome is for that person to be condemned, in some ways it makes it more just that we gave them every chance to explain themselves and their side of the story. 1.2c. A lawyer may limit the scope of the representation if the limitation is reasonable under the circumstances and the client gives informed consent. If you're a trial lawyer and you hate doing appeals, limit the scope of the representation so the client doesn't have in mind that you're going to see this through all the way to the bitter end, even when it goes up on appeal. If you're an appellate lawyer and you have no intention of doing the trial, if the appellate court grants a remand, spell that out and limit the scope of representation. More importantly, you have someone come to you and you're overwhelmed, right? You have trials booked back to back for the next 3 or 4 months. You can't take on anyone else. And an old friend or relative says, look, I have that, you have to represent me. And they say, look, would you just send a demand letter? And then if that doesn't work, I'll go find somebody else. And you go ahead, you can say, I will agree to make a phone call and send a letter, and that's going to be the complete extent of my representation. And then I'm done. Put it in writing and get the client and have the client agree to it. And so you can limit your representation to pre-litigation, right? Or to preliminary negotiations, or here's another one. You don't want to do a criminal trial, but you're willing to bail someone out of jail and show up at their arraignment and then pass the case to someone else. That's fine. You know what you're not allowed to do when it says as long as? You're not allowed to have them limit the representation to below the level of competence. Like, I don't really have to try, or I agree to represent you as long as I don't have to read anything. Or as long as I don't have to show up on time. So if you're going to limit the tasks you're going to do, spell out the tasks, but you don't get to generally limit your competence or diligence. D, A lawyer shall not counsel a client or to engage or assist a client in conduct the lawyer knows to be criminal or fraudulent, but a lawyer may discuss the legal consequences of any proposed course of conduct with a client and may counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, and application of the law. Okay, so just to make sure you understand, this should be an easy question, I think, if you get it on a test. You are not allowed to tell someone how to get away with a murder. You're not allowed to tell someone how to commit the perfect crime. You're not allowed to suggest to someone that they go and destroy evidence, right? That's off limits. On the other hand, you can explain to the client something like, if you do this, you could face criminal liability. On the other hand, if you merely did it this way and this way, or got a signature or got permission first or something like that, then you would be covered and it would not be against the law. Or get an opinion letter from the Attorney General first, whatever it is, you are allowed to counsel them about that. And that concludes the lecture. We're going to have another lecture where we talk about the comments to Rule 1.2.